বলবে হ্যাঁ আছে আছে চলে এসেছি
may be permitted to pray for leave to file without certified copy. And this is the same matter as not uh, the termination of the services of the teachers, that 36,000 teachers. And we are para teachers. The point is that we
So, think you leave, it will be appear as to be mentioned on Monday.
Lodge.
Please give notice to everybody.
My lord, I am mentioning one matter, my lord. My lord, for upgradation, my lord, item number 255 of combined list. My lord, urgency is, my lord. My lord, petitioner is an assistant school teacher in a particular school. From 2008, she is working in the school. My lord, my lord, she applied for the general transfer only basis of, my lord, single subject barrier, my lord, embargo. Her claim has been rejected by the honorable single bench. My lord, there is so many, my lord, petitioner only once applied prior to 22nd September. There is no embargo came into prior to 22nd September. Even, my lord, petitioner is suffering by various elements. I will take, my lord, 5 minutes, my lord, let it be updated.
Give the slip.
Lordship.
My lord, I'm praying for leave without certified copy, my lord.
When was the order passed?
My lord, 18 April 2023.
You have not got the certificate. When did you apply for the certified copy?
My lord, 2nd May 2023.
দিয়ে দিন। রাখুন।
My lord, I am for the বলে দাও।
certificate.
My lord, I am for the appellant.
My lord, I am appearing on behalf of the District Primary School Council, North Choice for my lord. My lord, disabled petitioner is 45% disabled. Well, after verification, my lord, the council send a memo for the approval, Commission of School Education, my lord, for appointment, my lord. Matter already sent to the Commission of School Education.
Give us a written instruction. You have said that you have to why don't you give us a written instruction?
ওই কাগজটা অন্তত দেখাও তাহলে অ্যাপ্রুভাল। This is a probably my lord memo of approval.
So
Which
you
is
agree,
sent to the my lord government for approval
so
by
you-
this memo, my lord.
So
I've seen-
you agree to whatever he has said.
My lord, if my lord they approve and my lord, they will my lord only to my lord issue the appointment letter. Commissioner পাঠিয়ে দিয়েছে?
হ্যাঁ। No,
Huh?
আমাদের কাছে এখন পাঠায়নি। Pending. Matter is pending, my lord, before the Commission of School Education, my lord, for approval, my lord.
On the basis of this, it can be disposed of.
My lord can be disposed of, my lord, directing my lord the Commissioner of School Education, my lord, within certain time, my lord, approval and my lord, then my lord, they are to my lord only the appointment letter.
Yes, my lord.
No, directing to act in terms of this letter.
Yes, my lord.
As your lordship, my lord.
Beyond the language of this letter.
My lord, as your lordship. I got your lordship.
ঠিক আছে।
কি করবে তো?
Party slash are represented in the order of their names slash names is printed above in the cost item.
দেবে তো অ্যাপ্রুভাল দেবে না আবার তবে তোমরা ঝুলিয়ে রাখবে না তো
Please take your seats. Please take your seats. At least you can discuss without the microphones catching your discussion. That is the advantage of sitting down and discussing. the party is first. Mr. Bhattacharya has come to court. Mr. Vaishya has come to court.
Yes, my lord. He is engaged, my lord.
Mr. Bhattacharya, no more than council appearing for the district primary school, 24 Pargana South, led by Mr. Vaishya, produces copy of a letter dated 2nd August 2022, whereby the relevant documents pertaining to the empanelment of the appellant / the writ petition for appointment as primary teacher in the physically handicapped P capital H within bracket PH bracket category C capital has been forwarded by the DPSC, by the chairman, DPSC, North 24 to the office of the Commissioner of School Education for necessary approval and or necessary instruction for further course of action. Mr. Bhattacharya submits the necessary action shall be taken on the basis of the said letter dated 2nd August 2022. Mr. Vishwas Kumar points out learned counsel appearing for the appellant / the writ petition points out that steps by the Commissioner of School Education on the basis of the said letter dated 2nd August 2022 within a period to be prescribed by court. Accordingly, no further orders are accordingly, no further orders are required to be passed in this appeal, except that the Commissioner of Commerce, Commissioner of School shall take steps in terms of the said letter dated 2nd August 2022, preferably within a period, preferably of 4 weeks. Within a period of 4 weeks. 6 weeks. MAT plan with CAN 1. Preferably, preferably stand recording be disclosed. Since no affidavit. Yes. The Commissioner of School Education will take steps in terms of this letter. We have quoted that part. And preferably within a period of 6 weeks.
My lord, it is pending before the Commissioner of School Education for last 1 year. My lord, your lordship kindly see the memo, my lord, August 2022. If your lordship, my lord, kindly, my lord, the shorter, my lord, this
4 weeks.
and my lord, after that, my lord, your lordship, my lord, the council has to give the appointment letter. Your lordship kindly, my lord.
We are said to take steps and to take steps. Beyond this, nothing is revealed. Otherwise, the matter has to be argued.
My lord, there is a just my lord, clarification. My lord, there is a 2 part. My lord, one is my lord from the Commissioner of School.
Has not commented anything on this.
My lord, after this, my lord, kindly, my lord, 1 minute, my lord, I will not take your lordship's much time, my lord. My lord, after this letter, my lord, they will send to the my lord council whether approval or disapprove. My lord, if approval is given, my lord, then council will, my lord, issue the appointment letter by 1 or 2 weeks, my lord. This is my only prayer, my lord.
Shall take steps. Shall take steps. And also further consequential steps
My-
here. No? As advised, as advised. These steps be taken within a period of 6 weeks.
Deeply obliged, my lord. Grateful.
Communication dated 2nd August. Be retained on the record. Item number.
May please your lordship's, my lord.
This is a group 6 matter.
Group 6.
So we are unable to continue.
What had better?
True.
What had it was?
Yes, Mr. Gold, this is a matter which has been kept with us for a long time. Start.
There is an application for compassionate appointment. Now, the father of the petitioner, that is appellant, expired on 27th May 2003. Within very short time, application for compassionate appointment was filed. An application was filed for compassionate appointment in due time. Now, my lord, then kindly skip over to page 15 of my application. Page 15. This is the recommendation of the branch manager. Now, the relevant portion is at page 18.
Yes.
Page 15 is the recommendation starts. Page 18, my lord, it ends. The Deputy General Manager, with his comments, subject to be corrected by your lordship, when at the first time of hearing, I placed this document before your lordship was pleased to opine that there is no signature of the Deputy General Manager. So far I remember.
Yes.
Now, my lord, the signature of the Deputy General Manager, I will present before your lordship from other documents supplied by my learned friend. I am grateful to him. Now, my lord, page 27 is the order. Without considering that recommendation, this order was passed. If I may use that expression, my lord, without disclosing or expressing any opinion as to whether the recommendation was considered or not.
Yes.
Now, immediately thereafter, my lord, the mother of the petitioner applied for lump sum grant. That is at page 28, annexure P3.
Yes.
Now, my lord, page 30, the authority concerned forwarded the application. Page 30.
Yes.
Now, page 31, the regional manager writes to the branch manager with the request to resubmit with the original application and other papers. As nothing, now no development took place, lawyer's letter was sent on my lord, 4th September 2014, that is at page 32.
Yes.
Then page 34 is the order, order impugned.
Yes.
So challenging this order, the writ application was moved and the order was passed, that is at page 36, which is impugned before your lordship.
Mr. Sinha, you have only said that the financial condition of the applicant was not found
not
to be
penury.
penury. Where is the finding? You
I
just
mean,
said here
in
on
my
the basis of a judgment of the Supreme Court.
in
Where
my-
is your homework on that?
But in my opinion, opposition, I'm enclosed it.
Please show us. Simply by saying that the condition is not penurious will not do. You have to support it by a formula.
My lord, the formula is there, my lord, because
Because
in the scheme itself, my lord says then a prescribed format is apply, prescribed format recommendation come, and then all things are collated in circle.
show us,
Let's report the competent authority.
show us your homework
I'm
from the
showing it.
affidavit. of- Take your seat. Where have you calculated?
Page 107, my lord.
Page
107. That is the collating all information request before the competent of the chief general manager. And all informations are earlier pages, my lord. What was the salary, what he was getting, everything. Page 104. And 104 is the particular, 104, my lord. It starts from 104. Then what is placed is 207. 107 is the post.
Look at page 108 bottom
108 water
in recommendation.
recommendation.
Then?
That is recommendation. That is approved by, that is approved through different authority. Then the CGM has approved it.
Or please read the recommendation.
Hmm?
Please place the recommendation.
Recommendations from different, well, the recommendation comes from branch, regional manager, DGM, Then personal department collates all this and they place this particular information.
Which information?
My lord.
Shows which
This page 7, my lord. What is placed?
page?
The page 7. 107.
That's right. The recommendation
lord,
is
then my
part of
lord-
page 107.
Then my lord come to page 109. Recommendations. 109 is the main place, what is placed before the chief government. Recommendations was not accepted. That recommendation was not accepted.
Where is the rule of the bank?
Rule. The scheme, my lord.
Yes.
Scheme is at page 17, my lord.
17.
17. This scheme was from 1979. It was amended from time to time. And my lord, in page 7, my lord, this was one amendment was made. Then revised scheme is enclosed. Last line, paragraph, last paragraph, my lord. Last 2 lines of the page 17. Last 2 lines of the page 17. Revised scheme is enclosed. Page 17, my lord. Some amendment was effected. We may overlook it, my lord. Last line, last 2 lines, my lord. Please instruct the staff concerned to enclose a copy of the revised scheme of corporation appointment for information record. This is a scheme of 2003 and he died in 2003.
Page
Page 17, my lord.
17.
17. Last 2 lines, my lord.
This was the scheme in 2003.
And my lord, scheme starts from page 18.
Now, where is the financial exclusion?
What are the things that we looked into, my lord? That is in page 21.
Page?
Page 21, my lord. Competent authorities, my lord. Time limit of submitting applications. Financial conditions of family we looked into. Taking into consideration all these aspects.
You have said,
Page
you
21,
have said, we'll come to that. At page 110,
110.
at 110, when you have rejected the recommendation,
That is the CJM recommendations. That
at page 108, when the recommendation was made, what
for-
was said? That after meeting all the dues, the payment of family income is 4,420 per month. 3,297 from family pension and 1,123, only 1,123 from liquid assets over liabilities.
Yes, ma'am.
You feel it's sufficient for the family of 2 persons. Have you checked up what is the medical condition of the mother? What is the requirement for medicine? What is the requirement for food? What is the requirement for rent? What is whether they own house or not? What are they only going to survive with food and water? So and then your bright officer at page 110 now says, we have examined the proposal. He is drawing his salary, basic salary plus DA plus all allowances. And he says, condescendingly, according to us, subject to correction by you, so-and-so died. Deceased family is eligible to draw monthly pension of 3,243 only, we can add the word. The surplus would yield 1,121 only. So with the price of fuel, with the price of transport, with the price of, you think this is enough for the family and you say he is not penurious?
My lord, one by
They
death
are going
cannot
to have
run.
only 2 meals a day. What about electricity bill? What about, what is the finding in terms of sustenance? What is your definition of sustenance?
What he was earning at the time of death and what he's getting after death. That is to
There is a
say,
line of decisions that
well,
even
my
this
lord,
is
what he was
insufficient.
getting at the time of death for salary. He was getting 3,000 or 4,000 already total. He was managing his family. By death, he can enrich his lifestyle, my lord.
Let us see, Mr. Sinha, what is your financial standing as far as the scheme is concerned? What are your financial exclusions?
Fairly scheme is 10, paragraph 10, my lord, page 21.
Article 21 becomes pretty meaningless. He has to just wear his clothes, sit at home and eat 2 meals a day. That is the life he is going to live.
But
You mean by
But he was a
non-penurious?
subordinate staff getting only around 4,000. Even after death, he's getting 4,000 altogether.
Let us see. Which is the page 24.
Page 21.
Yes. Financial condition.
Yes, ma'am.
Yes.
Then, my lord, he was getting 2,000, page number 107. He was getting. He was
Let us take this, Mr. Sinha. Sorry to interrupt you. Page 21. This is the checklist. Paragraph 10. First paragraph, 10.1, family pension.
Yes, ma'am.
Yes, you have taken into 2, gratuity amount received. You have taken into it.
Yes, ma'am.
3, employer's contribution to the provident fund. You have taken into it. 4, any compensation paid by the bank or his welfare fund, nil.
Nil.
So 4 goes out. 5, proceeds of LIC policies and other investments, which is only that 1,121. That is the only surplus.
Yes.
Income from family from other sources, 0. 6 goes out. 7, income of other family members from employment and other sources, 0. 7 goes out. 8, size of family and verifiable liabilities. 8, size of family is 2, verifiable liabilities. You have not verified whether he is saying in his own house, what is the repair cost, what are the medical liabilities of the mother. None of these verified liabilities you have mentioned.
No, see, family. He used to furnish in his application what are the liabilities. He has given names, he had taken loan from the XYZ, he has said that. He used to give some document, he has loan. But he was getting only 3,000 something. Last payment, last salary. He was a subordinate staff in 2003. And after death, he's getting around 4,000. With pension and provident fund. Because bank is to look, my lord, kindly, excuse me, my lord, I'm making submissions.
So please.
My lord, kindly look into that. In today's scenario, about 56% reservation is there. Scheduled caste, scheduled OBC. 4% ex-servicemen. 3% disability quota. Then thereafter, how many posts are vacant that everybody will take a cakewalk to get a job in the public sector, public sector, when millions of boys and girls standing in the queue, registering their name in the employment exchange are not getting a job. Here, he was getting 4,000 rupees. He's after death, he's getting 4,000 rupees. What is the hardness?
Where is the authority that what is penury, what is not? Do you have an authority, Mr. Ghosh? What is penury? What is Supreme Court has said, even if there is a non-penurious, even if you say this is the income, that will not bar consideration. Do you have the judicial authority with you? I think there are judicial authorities on the point that even if you say that this is the situation is that he is above the income level, threshold level, even then it will not bar a consideration to compassionate appointment. Where is that judicial authority?
Lord, I will supply the judgment.
When will you supply the judgment?
I will supply.
When will you supply? We have been hearing this matter for so many dates now. Why is your learned junior not prepared with those issues? Why did you not anticipate that these issues may arise during the hearing?
Lord, I will supply.
We have it with our notes. There is a line of authority that even if there is a financial assessment, you're found to be, as Mrs. Sinha is arguing, in a non-penurious condition. Even then, the judicial authorities say that no, that will not be a bar to considering your compassionate appointment. Where is that? What is the discussion?
I assure you, Lordship, that on 14th, my Lord, I will submit. If I fail, I will not pray for any more time.
You have lost your chance.
No, on 14th, on 14th, my Lord, I will submit the documents, the judgment.
This matter has been with us parted.
Yes.
You took several adjournments.
Sorry.
From 16th
It
of
was
March.
parted on my ground, my Lord, because I was physically not fit from time to time.
Your junior, what has he been doing then in court? Why has he not studied the brief and come with a perspective on what the argument, what the discussion can be like? He is merely there standing next to you. Why has he not understood the brief that this can be a possible line of discussion? Where are the Xerox copies? It's a question of a person's compassionate appointment.
I beg to be excused on behalf of my learned junior. My Lord, I assure you on 14th, I will submit the papers.
They just to stand like wooden dolls.
No, I will submit. Positively, I will submit.
Then we can prepare wax statues of them and just bring them to court. Why do they have to come in flesh and blood?
Henceforth, that will not be done.
No. We have Madam Tussauds. Now I think in Rajarat we'll ask wax statues to be produced of the learned juniors, and then we can just have the wax statue standing next to you. Yes, Mrs.
So 2003 he died. Thereafter he filed an application. It was rejected in 2005. Thereafter compassionate appointment scheme was withdrawn. Then the scheme of his gesture payment came. So his gesture payment starts, I have enclosed it also. Starts with the word that compassionate, that there will be no compassionate scheme in the bank. So after 2005, there was no scheme of compassionate scheme. I have enclosed it, my lord. Thereafter 2011, my lord, in two special, I have enclosed it also. Two special circumstances, compassionate appointment can be given. I just, my lord, see the page 25, my lord, Esgatia came, page 25. Just one line or two lines. Esgatia came, my lord, to page 25. Last paragraph 3, last 4 lines. The new scheme has come into force to the effect by 4th August 2005. This scheme will replace our existing compassionate settlement scheme referred to in paragraph 1. And no request for compassionate appointment shall be entertained or considered by the bank under any circumstances with effect from today. There is 4th chart. So after that, there is no compassionate scheme at all. So after 4th August 2005. Then, my lord, another scheme bank introduced. There is special circumstances. That is, my lord, a page 41, my lord. I have enclosed it. Page 41. Esgatia payment will continue, and then these special circumstances, exceptional circumstances. Page 41. Paragraph 3. Paragraph 3. Employee dying while performing official duty as a result of violence, terrorism, or robbery. Second, employee dying within 5 years by first appointment. These are two circumstances only compassionate permissible. So after 2004-5, there is no compassionate appointment. Then, my lord, again, my lord, the compassionate appointment scheme was brought in, and then the central government has requested a bank to introduce compassionate appointment scheme, my lord. That is in page 1. That is page 54, my lord. Indian Banks Associations, Indian banks, my lord at the time told me that we enclose all the schemes. That's why we wrote it. Indian Banks Associations wrote a letter to the ministry. The ministry is addressing a letter, page 54. It's a dual letter to Mr. Kamath, chairman of Indian Bank Association, down Malaysian there. It is written by the finance government, Minister of Finance. To open compulsory appointment PSB on the clients of central government, discontinue the provision of SGR scheme appointment in PSB. So again, confirmation of the comment wrote. Then the chairman of the State Bank of India wrote back to the finance minister at page 55 below. That our compulsory scheme and special scheme is running well. Page 55, my lord. This is a letter from the chairman of State Bank of India to the Secretary Finance Services. To the Finance Secretary. Here he reiterated that only the SGR payment scheme will continue. Along with that, these two special circumstances. Please later will read it. And the next page below, comment replied. Now, now again, can you reopen the scheme date of 2003, my lord? That you have a compulsory scheme, which has been last decision of Chandrachud, Honorable Justice D.Y. Chandrachud. He emphatically said compulsory scheme immediate penalty is looked into. That 2019 judgment, it is with me, my lord. Well,
Come back after recess. They have not done the homework. We will see whether the homework is in our chamber. Because this litigant we cannot give you time and after time.
Lord, I beseech your lordship to keep it on 14th.
No, we
I
cannot.
beseech your lordship.
It pleases us to now keep it in the next monthly list, or otherwise come back after recess.
Lord, I beseech your lordship.
No, we cannot. We have other time schedule. There are other stakeholders who want judgments from.
No, my lord,
we have to deliver those judgments.
subject to be
We are
corrected.
in the process of delivering.
Subject to be corrected, my lord.
We have to also honor our job.
My lord, I am going to be asked for myself. My lord, kindly,
No.
my lord, this is the last, my lord.
Sorry.
Kindly keep it on next week, any date,
No.
any date.
No, we will keep it after recess. We will do what we can do best. Duto সময় রেখে দাও।
My lord, oh,
Ask your learned junior to be here. Approve.
only thing is that at 2:30.
2:30 your matter is.
2:30 or 2:45, my lord.
Your matter. What time does that matter get over?
Pardon?
What time does that matter get over?
That will take much time. The office association matter is there. We will all just Abhinav Banerjee, my lord. Today is 3:30, my lord. Today is 3:30 is there. Up to quarter to
Sufficient.
But-
Yes, after this.
I'm appearing on behalf of the appellant. The pension granting authority have already taken steps to grant family pensions in favor of the deceased wife of the deceased wife. Your Lordship, I'm handing over.
না হয়ে গেছে
There is the copy.
হ্যান্ডিং আপ my lord the pension PPO.
They can, order the. Where is Mr. Shaktipada Jana?
Now he has got
This is exactly the kind of approach we think should be avoided, because today was most important day that he should have been in court. Has he come to court? Mr. Bari, you have Mr. Shaktipada Jana's number.
yes my lord, I have a
Please call him up, ask him to come. Very well.
Let the appeal be disposed.
disposed of in terms.
This has been handed over to,
Yes, yes.
Hand over. I mean, page.
I have given one to school
copy.
also. School has got.
Ashok. Chairman. No, we appreciate the assistance given by each of the parties. The widow has got a pension payment order after so many years. Whatever little money the widow has got, it matters to us. We appreciate the assistance of. We'll place that on record also, including yourself.
Parties are represented in the order of their names as printed above in the cross title. A copy of the pension payment order has been furnished.
Please take your seats.
In respect of Chandra Sahu. He was the headmaster of the Shamsundarpur Junior High School.
Please take your seat.
on the death of the said Mr. Shahu, his wife, Srimati Usha Rani Shahu, prayed for pension ending since long. As to whether the period of the absence of the said Mr. Shahu since Shahu would be with salary or without salary. Ultimately, being directed by this court on earlier occasions, the school in question calculated salary of Mr. Shahu received, and the said leave was assessed to be without pay. Pay. Stop. Said for the earlier ultimately the director of pension, provident fund and group insurance took steps and finalized the pension payment order, which has been placed, a copy of which has been placed but produced before the court. Paragraph. As the said pension payment order has been prepared, finally prepared. So this being FMA 465 of 2022, 465 of 2022 with CAN 1 of 2018. Stands disposed of. This court reciprocates wholehearted all the parties for the wholehearted approach taken by them in coming to a positive and fruitful culmination. The FMA 465, Senate Council's FMA 465, as the final pension payment order has been prepared and forwarded. So the FMA 465 of 2022 is being disposed of. And from this end, this court reciprocates for the kind cooperation of all the concerns.
What about area pension?
Area pension and area family pension. As per
Yes.
PPO, whatever amount,
It's all, so you have a copy of PPO is handed over to you in court today.
now I have received.
You missed the matter.
Obviously, my
Did you miss the matter? Today it is matter.
I have a matter in the Jalpaiguri. That is, I was engaged.
This possibly was equally important because your client was
Extremely,
waiting for a pension and the court was involved, all the parties were
extremely
involved.
sorry, my lord. Extremely sorry, and my lord.
Junior was also not here.
Extremely grateful to your lordship. So otherwise, my lord, she will.
So you have not had a look at the pension payment order till it is handed over to you in court. So your client also would not know whether the pension payment order. Your presence today was very important.
Not yet, my lord, the pension payment order, not yet, my lord, received.
Therefore, your presence today or your junior's
yes,
presence
I
today was
understand.
very important for the
Extremely,
life of your client.
extremely sorry, my lord.
What can we, so being sorry to us is not an issue. The fundamentals are more important. To the life of your client, for which the court has been working, we have been all been devoting some time. Today's pension payment order, for you to see it and read it was very important. Whatever the matter, even in a matter in a Supreme Court maybe. To place somebody here to receive a pension payment order. Your client her husband was not traceable. She's a widow. For years, pension has not been paid. Today, the pension has materialized. What is important now? You tell us. Disposed of.
I am extremely grateful to your lordship.
My lords had this matter on 4th of May. After hearing me, as my late friend was in difficulty, your lordship adjourned the matter. If your lordship say that I can start, or if your lordship wants to hear my learned friend, it's your lordship. The order under appeal starts from 33.
On the last occasion, the learned counsel on behalf of the state had not appeared.
Yes, but
Yes, sir.
I
I am for the state.
concluded, if you, yes.
Let us start.
Should I start? The order under appeal starts from page 33. In gist, I am telling your lordship, the petitioner was appointed as assistant teacher with MA B.Ed qualification in the year 99. At that relevant point of time, the ROPA 90 was yes, the ROPA 90 was in force. The pay scale of the teacher or any employee is should be fixed in accordance with the ROPA. In the meantime, in 1994, our government, should I continue? 1994, that is exactly of 6/12/1994, memo number 865, the government has floated a policy that if for the interest of the institution, if any assistant teacher is appointed in regular session, that means from class 6 to 10, but he or she got the higher qualification, but with the master degree, then this the post concerned may be converted in for the higher section. On the prayer of the school authority, the DIF school has converted the post from general session to the higher session, that is by his order dated 13 September 31st October 2005, and in that memo, my lord, he has fixed his scale commensurate to his master degree from 2005. The petitioner's claim is that he is entitled for his higher scale commensurate to his master degree from his initial appointment. For that matter, I have placed before Lordship the ROPA 1990. I have handed over a copy, if it is a ROPA 1990. Lordship, kindly come to clause 16 of that ROPA rule. This is the ROPA notification 33 EDNB 16, clause 16, career advancement. Now, clause 16, career advancement scheme and related issues. Lordship, kindly come to subclause 3. May I read for your lordship? All teachers and librarians of secondary schools who have improved, will improve their qualification, or next portion is relevant for the appellant, who were appointed with higher qualification.
What is the interim order you're expecting?
No interim order. Your
The
lordship.
matter has to be heard on affidavit.
And the writ petition has to be before your lordship. The writ petition has not been
Let
annexed.
it be there. You have
No, only your lordship
your
was
affidavit
kind enough to
No,
fix this matter on 6th.
then
He is going to retire within 2.5 months. No? Or
within how many years?
within few months, 2 or 3 months. Right?
File your affidavit to be as early as
I'm
possible.
grateful, lordship.
Otherwise, this matter cannot be heard out just as without him disclosing his stand. And what about the writ petition?
Well, they have used their affidavit, they disclose their stands.
Have they used an affidavit?
My lord, we have used our affidavit, my lord. These affidavits are not before a lordship in this appeal, my lord. And my writ petition also not been annexed. So my lord, the paper book, informal paper book, if my lord, my friend, senior friend is my lord, playing so, my lord,
Yes.
informal paper book.
Then no further affidavits are necessary.
Yes, my lord.
Informal paper book, how soon can you get?
Well, I can prepare within 1 week because
Very well. Then it will be in the monthly list of July under the heading
Grateful,
hearing.
Yeah.
He is retiring in how many months?
on November. I'm told November.
So July within the first 5 matters.
I'm grateful to your lordships.
Grateful. Full. Share with us. What happened? Can tell us what was the age in which he affirmed the affidavit?
He affirmed this affidavit. Lordship kindly comes to his affidavit. I was calculating in this.
You're
this
correct.
year.
58 years as on 15 September 2022.
Yes, my lord.
Yes,
So 23, 59 years, 60. That's right. He is to retire.
he is going to be.
Okay.
On it also, your lordship asked this question.
Party parties are represented in the order of their names as printed above in the first title. Mr. Dev Bormon, counsel, appearing on behalf of the appellant, submits that affidavits have been exchanged before the writ court. Full stop. The learned Mr. Writer of the appearing on behalf of the state submits that the affidavits and the affidavits which have been exchanged before the writ court, the writ petition and the writ petition are not part of the have not been made part of the memo of appeal. Have not been made part of the memo of appeal. Stop. In such paragraph, considering the submission of both sides, let informal paper book be prepared incorporating the writ petition and the affidavits filed before the writ court and to full stop. Let the learned counsel appearing on behalf of the appellant, learned counsel appearing on behalf of the appellant further submits that the informal paper books that he shall furnish the informal paper books, that he shall furnish the informal paper books, requisite number of informal paper books within 2 weeks. From the
I can prepare it by within 1 week, consider it.
within 1 week, within 1 week, full stop. Considering paragraph, considering the fact that the appellant is going to retire during the month of November,
November, and October. Lordship, October or November, I'm checking the exact date of
during this year,
September 15 and yes.
during this year.
Yes,
Within the last part of this year, within the last part of this year, let the matter appear within the first 5 matters in the combined monthly list of July 2023. In the combined monthly list of July 23, within first 5 matters.
I'm grateful to Lordship.
I'm so grateful to Lordship.
Under the heading group 2.
Hearing group 2.
Falguni Babu, under the heading hearing group 2, let advance copies of the informal paper book be
Lordship.
served. আর যেহেতু জুলাইতে আসছে, let it be 2 weeks instead of 1. তাড়াতাড়ি করতে গিয়ে নষ্ট।
Yes, my lord, I am for the respondent number 1, the writ petitioner.
I am for the appeal on behalf of the appellant, Lordship. Lordship, here, Lordship, very short question, Lordship, very short question. Raw point is there, Lordship. One, Lordship, District Primary School Council made an advertisement 2009, recruitment for the assistant teacher, Lordship. On the advertisement, Lordship, page 13, my paper book, page 13, is clearly mentioned, Lordship, 10/6/2000 তারিখের পর 12/6/2000, kindly see the Lordship, page 13. Point number 6, Lordship. Last paragraph. Page 13. Kindly see, got it, Lordship, page 13. Page 13, last paragraph, paragraph 6. 12/6/2000 তারিখে পরে পদ্ধতি কোনো শ্রেণীগত সঞ্চয়পত্র গ্রহণযোগ্য হবে না, সকলকে সহযোগিতা পায়। That is my last cut up mark, Lordship, here 12/6/2010. Any Lordship certificate should be submitted within 12/6/2010. But Lordship, my client did not produce any scheduled caste certificate. He certificate issued on, Lordship, kindly see the page 14. Page 14, Lordship. Page 14, Lordship, last Lordship, 25th August 2011. My cut-off marks is 12/6/2010, but he produced the certificate has been issued by the subdivisional 25th August 2011, Lordship. Thereafter, Lordship, the matter was heard before the trial court. Lordship directed me to file a report. I file a report, Lordship, page kindly see 53. Page 53, paragraph 7. In my report, Lordship, I stated in paragraph 7, Lordship, page 53, kindly see the grievance of the petitioner raised is not justified, as the petitioner has been considered UR category candidate, though he applied for STEC candidate, because at the time of advertisement by DPSC, not 24 Gara, on 21st April 2010, he does not belong to ST category as he get the ST certificate from competent authority on 25th August 2011. But he wrongly applied ST category also fails to produce any authenticate document certificate of executive category at the time of verification. So he was treated as a general category, UR candidate. The total mark score obtained by the candidate is 22.39. Whereas the mark score the last impanel candidate UR category in Bengali medium obtained 30.88. That's my Lordship. Here, Lordship, lots of candidates is there, Lordship. Every matter, Lordship, I Lordship, remember, Lordship, on the Lordship schedule land user certificate, Lordship directed, if you land user directed by the district magistrate to produce that land. Lordship, with the 6 or 7 petition, Lordship, file the report, last DM, file a report, yes, he belong to the Lordship. But here, Lordship, I have mentioned my cut-off marks is 2010, but certificate is issued by the 2011. And Lordship, if he not produced on that time, so Lordship, he treated as the UR category. That's my short position.
What has the single bench, Mr. Boisho, decided?
So single bench, Lordship, pass an order, Lordship, kindly. Lordship, kindly see the page 60. 60.
He applied as a scheduled tribe candidate.
Lordship.
He applied.
No, Lordship. When Lordship is on the
His application form.
application form, nothing to any, only for the Lordship on the basis of he in the application form, he say I am the scheduled caste, but not annex any certificate.
That's right. What was your when were you to scrutinize the application?
Lordship, that Lordship, I am Lordship here. Scrutiny report is pata hai. Reporter লিখেছি দেখি রিপোর্টটা দে.
When he appeared for the written test and the interview, he produced the certificate.
No, written test he produced, Lordship.
Yes.
But here, Lordship, I have clearly in the advertisement, I have mentioned, if after that 2010, he is not accepted. On written test, schedule caste certificate issued in 2011 August. My Lordship, my advertisement clearly stated in the 12/6/2010, after that, no certificate, no any document has been accepted. Once again, Lordship, kindly see my advertisement, Lordship. My advertisement, kindly once again.
Where is his application?
If-
Where is his application for appointment?
Appointment, Lordship, what?
He applied for appointment for the selection. What did he, his application, what did he say?
application to बताओ admit करते थे
Page
admit करते थे
37.
lots 37 lots.
This is application first.
That is the lordship. Kindly see the page 37 lordship. Received an application for the ST certificate from Tapos Panja. 2002, 2012, 12-9. On that time, lordship, we don't need to produce any certificate, lordship.
Now page 39.
Pen 30 admit card, lordship. Only lordship, we fill the form of the ST on the basis of the fill the form. Admit card is issued on the basis of the lordship application form, not for the verify or anything, lordship. We fill the form on the I am the schedule card on the basis of the application form. The admit card was issued. এটা কোনটা এটা ফর্মটা 2009 তো হয়েছিল 2010 ফর্ম দিয়েছিল এক্সামিনেশন কখন ছিল but here lordship when the lordship 2009 process is going on one lordship matter was heard before the Hon'ble High Court. High Court passed the order to director of the education department and stay of the operation and the director by the education department kindly see the matter. Thereafter, lordship, that examination was cancelled, lordship. Thereafter, the further examination was held, but lordship, advertisement and admit card is the same, not change anything. But only for the lordship, written examination was held after that, 2004. But lordship, on the 2012, the admit card is issued anything, there is no change at all. Only for the examination date has been changed by the lordship education department. Thereafter, lordship, one advertisement made by the DPSC that the lordship examination will be held on such and such date. That's it. Thereafter, matter was heard, lordship, lot of one advertisement, the matter was heard before the division, single bench, division bench, before the Supreme Court. Thereafter, panel was published, and after the direction of the single bench, the panel was prepared, and thereafter panel was published, lordship, on 2021.
Where is the advertisement, Mr. Bosho? You are
Advertisement page 13, lords.
1-3.
1-3, lords.
Yes, how have you tackled this part? Page 13,
Yes, my lord.
last line, you knew when you applied that you
Yes.
did not have the certificate. So how did you propose to cross the hurdle then?
Then order impugned has clarified, my Honorable Justice, single judge.
What was working in your mind? That you will produce the certificate later and you can escape the rule? I was just asking your reaction.
Yes, my lord,
This is the
my
line.
lord,
When
that
you
is-
applied, you
that
did
is
not have the certificate.
not in my fault. I have applied before that advertisement, 2009,
Correct.
but the certificate.
But your application ought to have been rejected then.
Yes, my lord, I am coming, my
We are
lord.
also sharing the.
My
Your
lord, I am
application
coming, my
when you
lord.
applied, at that time, the board should have rejected your application. It is not accompanied by a certificate.
Yes, my lord, I'm coming, my lord. But that
This is
without
the
fault,
problem. You keep candidates who are on the threshold.
Yes.
We are not saying on merits right now, it's the right. They are keeping candidates on the threshold and allowing them to develop a right. They should have been rejected right then.
my lord, my lord,
Board has
that,
not acted.
that certificate has been issued after 2 years. And it is the fault on the part of the respondent, state respondent.
Not the
I have-
DPSC.
I have their case that has been Supreme Court, Honorable Supreme Court judgment that has been referred or mentioned in the order impugned. I am coming, my lord. I shall produce, my lord. I shall produce that
judgment. And before that, my lord, that kindly come to page 38. It is that at the bottom in the left-hand side, Lordship will kindly see that the ST, because that receipt copy has been given in the application, and that has earlier a learned friend has mentioned page 37.
True. We are talking aloud.
Yeah.
There's no true. But as far as page 13 is concerned, is that a certificate?
Yes, my lord.
Is the application a certificate?
Yes,
Can it be
my lord.
treated
My
by
lord,
the
I am
board?
coming.
This
That
is
is
the mistake the board has been doing. We should have
That is
allowing you to sit for the examination
that is
on
the
the
cla-
basis of an incomplete certificate. And
That
now
is
we
the-
have to explain the situation.
that is the Honorable Supreme Court was pleased to clarify.
Show us, what did the Supreme Court say?
And that has been mentioned in the order impugned. My lord, I am giving my lord. Page.
There is no
Page
quarrel.
63, my lord.
There
Page
is no
63,
quarrel.
my lord.
There is
Kindly
no-
come to page 63. I am producing that.
Show us the judgment.
And on the basis of that judgment, the Honorable Single Judge was pleased to pass this order. At the bottom para, the Honorable Supreme Court in the matter of Ram Kumar Girjua versus Delhi Subordinate Services. That central theme is he was not the new certificate. By birth, he is ST. And I have also a certificate of the headmaster and also.
Yes.
Yes.
But if you say that
Yes.
a particular authority,
Mm.
please don't understand that we are drawing a conclusion now. We are asking questions because we have to ask questions. If there are so many candidates for that particular examination, so everybody says I am ST, I am SC, but does not give a certificate to that effect. How is the recruiting authority going to screen the candidates?
Yes, my lord, that is the point of the Honorable Supreme Court, that at the time of consideration, means at the time of interview, if the document is produced, then should be considered, because before the, my lord, that examination is the de novo. My lord, kindly come to page 70, that the Honorable High Court was pleased to order that earlier examination will be cancelled.
Let us read this judgment and
Yes,
then we'll
yes,
come
my
back.
lord.
Please take your seat.
Yes.
Yes.
Yes, my lord, that paragraph 18 is more relevant, that the constitutional bench, ninth judges bench has decided it, as that has been mentioned in this judgment, that paragraph 18. Now, my lord, another judgment has been mentioned in the order in view, my lord, page 63, first para. I am producing that. একটু kindly দিন না। That the merit on that the better candidate will be taken chance, the better candidate, and on the procedural hazard that cannot be destroyed the fundamental right under Article 16(4). Now I can produce, my lord, if your lordship is pleased to permit me, that the procedural hazard should not come in the way of the substantive right or the substantive act. My lord, that relevant paragraph is 15. To save the court's time, I am that paragraph 15 is more relevant.
Yes.
Yes, well, that another, though it is not relevant to the teaching appointment or anything, in a land acquisition case, Honorable Supreme Court was pleased to opine that the my lord, the rules of procedure are the handmaiden of justice, and the procedural hassle cannot come in the way of substantive right of a citizen under the Act. My lord, I can give that judgment, my lord. A last page, that is the relevant. এই জায়গাটা দেখি আমি আরেকটা কপি দিচ্ছি, দাঁড়ান। 270 page এই জায়গাটা। Yes, my lord, that page 270, paragraph 16, last portion. That if your lordship is pleased to permit me to hand over list of date, because their list of this is very short. Huh? And earlier examination was cancelled by the education department, my lord. And de novo, there is a direction of the Honorable Court of High Court, my lord, 60, my lord, page 70, my lord, of the application, page 70 of the application, that they have annexed, my lord. Honorable Justice Tawabroto Chakraborty was pleased to pass. And my lord, I am just, page 70, I am just read out. Mr. Gupta, learned senior advocate, appearing for the petitioner in such and such, submit that in view of the serious irregularities in the recruitment examination, the same were cancelled by the government order number such and such, with a direction upon the chairman of the TPSC to conduct the recruitment examination de novo. If the process is entire gone, then the advertisement in the date that cannot be exist in such a way, because it is a de novo. It is a de novo proceeding. Earlier admit card was issued. My learned friend has wrongly submitted that admit card was earlier first examination was issued, and examination was held according application prior to the advertisement. My lord, kindly list of data I have said that prior to the advertisement, but that state respondent, one of the respondent is responsible that the ST certificate has issued 2000 letter. But the question is, the certificate is not a new qualification. By birth, he is ST, the scheduled tribe. Poor man, scheduled tribe, his father, mother, all are scheduled tribe. But my lord, if you're kindly, lordship, permit me, the school, in the high school, he has obtained the stipend of the ST. And MLA has issued the ST certificate. If I can produce, my lord. My lord, in the contempt petition, I was annexed, my lord.
Yes,
I have
that will be enough.
Yes,
Mr. Vaishyo, the Supreme Court judgment binds you. That is, the Supreme Court judgment is pat on the point.
mentioning the ordering.
You have as a conducting body, maybe no fault. This cannot be treated as a precedent also. But the contents of this judgment,
I have nothing to say.
bind.
But here, lordship, as for the birth lordship schedule caste, I have no lordship application as the
So even on the point of later submission of
that lordship, as per the schedule caste, is the lordship bond schedule caste. That's why I'm nothing to say anything in the Supreme Court.
you could have distinguished this case.
But I am
from other
doing
cases.
some document.
But the
Give me
Supreme
some
Court
time.
judgment
Lordship. If the
binds.
lordship possible, lordship, there is some document I have sort of note lordship there. If they give me a permit to lordship, if I find any distinguish is there, lordship, then I.
No, we are disposing it off.
So give me some judgment he cited. Give me some number. My junior
No,
friend will also-
that judgment has been mentioned in the order in
The order is there.
No extraneous
I am-
judgment I have produced.
Lordship.
The two judgment has mentioned in the order impugned.
Yes, we are
Page 63.
Bosh, please. Of course, we are not treating this as a precedent.
No,
but
I am not.
the
lordship,
situation is like
lordship.
this. But the Supreme Court judgment says.
Yes, my
Yes,
lord,
yes, lordship.
even in the constitutional bench
Party.
referred that 9 judges bench.
আমি বলে দিচ্ছি।
আগের দিন আছে নাম জানে ওরা।
That are presented in the order of their name, names, written above in the prospect. Please take your seats. The short question, which is a reason for consideration of the Supreme Court. Arises out of the delayed submission of his scheduled tribe, S capital T capital within bracket ST bracket close, certificate by the writ petitioner / the respondent number 1 to this appeal, while appearing for selection as a primary teacher in 2009 under the District Primary School Council within bracket DPSC bracket close, 24 Parganas North. First, Mr. Vaishyo, at Senior Counsel, appearing for the appellant / the DPSC with Mr. Bhattacharya, at Counsel, points out that the Honorable Single Bench the Honorable Single Bench fell into error by the last date for submitting the ST certificate by the writ petitioner as specified by the recruitment notice for 2009 was the 12th of June 2010. since admittedly, the writ petitioner obtained his certificate on the 25th of August 2011, that is, i.e., after the last cut-off date, his application to be treated as a ST candidate could not be processed. Full stop, para. Per contra, Mr. Roy, learned counsel appearing for the writ petitioner, submits that the Honorable Single Bench had taken note of the fact that the writ petitioner had applied for his scheduled ST certificate, prior to the cutoff date, applied on the 22nd of December 2009, that is prior to the cutoff date. Full stop. It is not the fault of the writ petitioner that the writ petitioner obtained the certificate ultimately from the concerned state authority, S capital, A capital, on the 25th of August 2011. Full stop. Para. At this election, the writ petitioner had throughout declared his ST status. Full stop. Both the written examination and the interviews were delayed and held subsequently pursuant to intervention by the Honorable High Court. Full stop. At the selection stage, at the subsequent selection stage, the writ petitioner was issued with a fresh admit card, wherein his ST status was clearly mentioned. Full stop. It is submitted that the writ petitioner also carried his ST certificate, granted ST certificate at the time of scrutiny during written test and interview. Full stop. Para. Mr. Roy places heavy reliance on the authority of the Honorable Apex Court as reported in 2016, Volume 4, SCC 754, in the matter of Ram Kumar Gijroya versus so and so. Full stop. Mr. Roy submits that the decision of the Honorable Apex Court is clearly binding on the point that once a candidate is a scheduled caste or scheduled tribe, once a candidate belongs to the scheduled caste or scheduled tribe, once a candidate belongs to the scheduled caste or scheduled tribe, and even any other category, and scheduled caste, scheduled tribe, and other backward classes, the such status of the candidate does not change. And in the spirit of the constitutional reservation process envisaged, and in the spirit of the reservation process envisaged by the Constitution and interpreted by decisions of the Honorable Supreme Court, the policy of granting fair opportunity in public employment to reserved category candidates who have otherwise been declared successful in their category, in their respective categories, should be followed as a constitutional goal. Full stop. Para. In this court notices that in Ram Kumar Gijroya within bracket Supra, comma, the OBC certificate had been applied, had been submitted by the candidate subsequently, as in the facts of this case, and following the principle of law laid down in Gijroya within bracket Supra, Gijroya italics Supra italics comma, the OBC certificate, although subsequently submitted, comma, was allowed to be acted upon by the recruiting authority. Full stop para. This court is also taken to the decision impugned of the Honorable Single Bench dated the 31st of March 2022, which takes judicial notice of Ram Kumar Gijroya within bracket Supra, bracket close, full stop para, having thus considered Mrs. Unanamprati from a learned advocate appears for the state respondents. Also having considered the materials placed, having heard the parties and considered the materials placed, comma, although this court finds this court finds no reason to interfere with the judgment and order of the Honorable Single Bench, having regard to the principles enunciated in Ram Kumar Gijroya within bracket Supra, full stop para, accordingly, comma, MAT blank of blank with blank of blank, stand dismissed. Full stop. All parties to act. Yes. That
Another judgment has not been mentioned.
not required. Not necessary. Not every judgment is required to be discussed.
Sorry,
If
sorry,
we feel that judgment has become insignificant in terms of Ram Kumar Gijroya. If we feel that even the board had a point, but for Ram Kumar Gijroya.
I accepted that the 9 bench.
That's it. If you did not have Ram Kumar Gijroya, you may not have walked away with an order like this today.
No.
Any.
জানে তো নাম জানে তো দেবো Well, this matter may be taken up on next Wednesday.
Not this week.
Wednesday, next Wednesday.
Not this week, next week. You'll come back in the list next. Not this week.
Again, Monday, my lord, I have to come. Because Mr. Bhattacharya is appearing, my lord, I don't know where is he. But no information is there. So, my lord, I have to talk with him.
দিয়ে দিও বিমল পরে বুধবার
Wednesday.
মানে না শুধু লিস্টে থাকবে there will be no mention of any date or just লিস্টে থাকবে yes yes
My lord, learned senior advocate Mr. Bikas Ranjan Bhattacharya is appearing in this matter, my lord. I'm praying for a time of a week subject to my lord's convenience, my lord.
Third time, my lord will see from the orders adjournment was taken. Last time on behalf of Mrs. Koili Bhattacharya. Anyway, adjournment was granted and a disciplinary proceeding is stalled. a proceeding which was sought to be initiated by the board pursuant to an order of the division bench. On the last time, Mrs. Bhattacharya, who appears for the board, she's time of it.
Come back next week. What can be done? Only not this week.
Grateful, man.
You appear, Mr. Chatterjee, for the
I'm for the writ petitioner. She was a cancer patient. She still is a.
you are the appellant.
There. I'm the writ petitioner respondent.
What was the order?
I'm the writ petitioner.
What was the order before the single bench?
The
That's page, internal page 20.
Your senior is there with you. Are you appearing for?
For the statement.
So Mr. Chatterjee is, yes. Yes, well, let us see the order. We please wait. Yes, let us see the order.
ডিভিশন বেঞ্চ বলেছে ইন্ডিপেন্ডেন্টলি করো
না করো না, করতে পারো।
হ্যাঁ তার থেকে অর্ডার দিয়েছি
তাতে কি করেছিল তারপরে?
অর্ডার দিয়েছি
কই আমার কাছে কিছু কাগজ ঠিক কাগজটা দাও, কি করেছে?
সেটাই তো চ্যালেঞ্জ করেছে ক্যান টুতে
কি করে ক্যানটা দাও, দাওনি তো?
আমি কেন
কে ক্যান করেছে?
আমি রেসপন্ডেন্ট
ও করেছে, আমাকে ক্যানের কপি দেবে। হবে না,
আগের বার ডাইরেকশন হলো তাও তাই
আমাকে দেয়নি কপি, এটা দিয়ে দিতে।
তুমি তো নেই কাগজ পাবো তো
এই আমাকে ক্যান ছাড়িস হ্যাঁ, কবে দিবি? ক্যান কবে দিব?
ক্যান
ছিলেন না আপনি কি দিয়েছেন? আচ্ছা তোমার কাছে আছে ক্যানটা?
হ্যাঁ তো
দেখি কি দিই।
আমার ঘরে তো এক্সট্রা আছে
তো দিয়েছে তখন তাহলে নিশ্চিত খুলবে। তুই আমারটা দিয়েছিস, কি হয়েছে?
এইটা পাস করেছিল এটা চ্যালেঞ্জ করেছি একদম জানতে আগে করেছিল
হিয়ারিং দিই, তাই তো? হিয়ারিং দিয়ে কি করে?
The Honorable Division Bench has heard the matter, Malan, and a different.
We are asking you a different question, Mr. Chatterjee.
Malan,
We are asking you a question which is occurring in our mind. Will you answer that first or make your submission first?
but what is the question?
So can we frame our question to you? We have read the order. Have you received your benefits now?
In 2022, after the order of the Division Bench, when I've got the benefits.
Now, you have got the benefits. That is number one. Which is the order of the division bench which gave you the benefits in 2020? Please, we will hear you, but you please respond to our questions first. Because we are framing questions after trying to read the brief. Yes.
The order of the Division Bench, Malan, dated 26 May 2022 in this appeal.
Yes. Now, what your position is, you have received those benefits.
Yes.
After that, Mr. Chatterjee,
The Honorable Division Bench had modified the order of the Honorable Single Judge to the extent, Malan, the Honorable Division Bench had left it open to the board to conduct proceedings if it so felt it was necessary.
Then-
That exercise was also carried out by the board.
then-
That order is at page 34 of Manan Can 2. Can 2. There's a different application apart from the state petition.
Yes.
Page 34. My lord, and the last paragraph of the order, my lord, is the reasoning at page 35.
Yes, then
After that, my lord, this application, my lords will find, was filed, my lord, sometime in 2022. And I had, in fact,
which application? This can 2. Then what happened?
then nothing has happened, my lord. This application, the purpose was to keep the proceedings stalled. To that extent, the application has succeeded.
When was this appeal filed?
Appeal was filed, my lord, in summer vacation of 2022. This can 2 was filed in June 2022.
Can 2 was filed by whom?
By the respondent headmaster.
After the board passed the order. What is the order passed by us on the last occasion? Yes. So you want can 2 to be heard out?
I want can 2 to be heard. There's another facet to this. In my affidavit in opposition to can 1, I had placed on record that the headmaster is running a parallel primary school from the private primary.
Show us that part.
That affidavit is there.
Where is that?
It has been filed before the Honorable Division Bench.
You have filed before the Honorable Single Bench.
Honorable Division Bench.
So it should be before us.
It must be before, my lords.
Yes.
And the back sheet of Aniruddha Mitra, my lord. My lords have got
Yes.
not
Back sheet of Aniruddha Mitra. Yes.
Here, my lord, my lords will find, my lord, I've made several allegations. Apart from the running of the primary school from the locality, I have annexed, my lord, documents from the state government website to show how the headmaster has in fact amassed wealth. He has gone on to, my lord, purchased, my lord, several, my lord, plots of land in the locality, and they were all reflected naturally in the government website. I say that is the illegal gain from the primary school which runs over there. And my lord, the other teachers are in fact, my lord, so my lord, scared of the repercussion that may have, they do not dare to complain. That is, when apart from the gross inordinate delay for which I blame the headmaster, the board apparently has concurred with that. But I have a list of dates to support that. And this is another facet of the entire thing.
Yes, the board.
And first of all, this affidavit is not with me. It has not been supplied to me.
I've served, my lord, the appellant. I'll serve my learned friend.
Well, initially,
Has not been supplied to you?
no.
What has not been supplied to you?
This copy
Of the affidavit, you know.
is referring.
Very well, that will be supplied. Your next problem?
No, my lord, we have first the single bench directed to take action against the headmaster. Thereafter, there was a stay and said if board finds, then proceed upon it. So, my lord, we have given a hearing and we have said that this disciplinary process should be initiated. My lord, thereafter, what is the stage of the proceeding that I have to take instruction, your lordship.
When can you address this court?
I'll take instruction.
You tell us when can you address this court? Tell us when can you address this court?
Next Thursday.
First matter. Mr. So-and-so, learned advocate, appears on behalf of the appellant and seeks an accommodation. Full stop. Para. The respondent number 1 / the writ petitioner is represented by Mr. Chatterjee, learned senior counsel, with Mr. Mitro, learned advocate. Full stop. Mrs. Koili Bhattacharya, learned senior counsel, represents the West Bengal Board of Secondary Education. Para. The state is represented by Mr. Shumon De, Learned Counsel. Full stop. Mr. Chatterjee emphatically points out before this court the facts as discussed by the order of the Honorable Single Bench impugned in this appeal are such that they shall shock the conscience of this court. First, accordingly, Mr. Chatterjee further points out that the matter be considered expeditiously, since there is a tendency shown on behalf of the appellant / the headmaster of the school in issue to delay the hearing of the appeal. First, Para, it is further sought to be demonstrated by the respondent number 1 / the petitioner that the appellant / the headmaster of the school is making illegal gains from the property of the school and is full stop. This court has heard the parties. This court has also considered the materials placed. Full stop. Para. Let this matter appear for consideration next on the 14th of June 2023.
Thursday is 15th, my lord.
We are free on the 14th. You have difficulty.
Two PM, my lord. It suits my lords.
পরের সপ্তাহটা দাও 19, 20, 21 দাও on the 20th of June to 2023.
What's not 20?
20. Yes. You will not be there.
No, I'll be little late.
But then there will be difficult.
I'll be little late.
No, Bimal,
But 14th, my lord, at 2 PM, if it comments to my lords.
original site. On the 21st of June 2023, at the first sitting of the court. When parties undertake to assist this court at the hearing.
I'm grateful. I'm sorry to have caused annoyance.
No, but if you had not pointed out, you would not have seen these facts. You cannot just walk away just because he wants to walk away. You did your duty, you did your job. We did our job. He also has done his job. We have to meet again to resolve the issues. Yes, the facts are such, they require an adjudication. আসুন আমাদের আরেকটা next matter. Yes.
I am for the appellant, my lord.
Let me come for the respondent. সঙ্গীতা বিশ্বাস
My lord, petitioner participated in the primary teacher, and thereafter her name appeared in the she was empaneled, and thereafter the primary board called, published a list for counseling. That counseling process, in the counseling process, no letter of counseling process was sent to her, and thereafter the counseling process was over. Thereafter, she filed a writ application before this honorable court. That was dismissed by the learned single judge. And on similar occasion, similar facts, Justice Gangopadhyay passed an order that when the counseling process was conducted, letter of counseling should be sent to the petitioner. And that was not done by the board.
You were not well, you missed the list.
That is that.
Then it could not come back to you again, the opportunity.
No, my lord, kindly see the.
This is not endless compassion. Recruiting authority has to do a job according to the recruitment notice.
That is.
They call people.
No.
They called you. You missed the list. You
No.
did not get information. Then no recruitment will be completed.
My lord, board has published the list in the website.
Then what were you doing?
And the date of counseling was published in the website. No letter of counseling was sent to the petitioner.
Website, today's electronic age, Mr. Das, we understand the difficulty. We had a matter about 1 year back when 2 students said they could not appear for the COVID selection during Madhyamik time, Madhyamik COVID selection. They were without smartphones. What can be done if the other 98 students appeared and those 2 could not appear? How can the board make out an exception for them?
No, my lord.
Tell us.
That is true, but your lordship kindly see page 90.
No procedure will be complete then, Mr. Das.
Your lordship kindly see page 90. Page 90, I have annexed the order passed by his lordship, the Honorable Justice Gangopadhyay, where his lordship specifically held that Rule 10 also does not say that the intimation should be or only be SMS by phone call or by publishing a notice in the official website of the board. The word call connotes a letter also. Therefore, it is an admitted position that no letter was issued to the petitioner by the board calling her for counseling. Here, my lord, no letter for counseling was sent to the petitioner. No letter for counseling was sent to the petitioner. Therefore, she could not participate in the counseling process.
We will.
Counseling process.
Today, Mr. Das, we are running out of time. We will continue with the consideration.
My lord.
Today we are running out of time. We will continue with this consideration next week.
Next week. Yes, my lord. As your lordship. As your lordship.
Third week at the 19-20-21 ওই সময়টা আসুন Mr. Bishwas, Gaur, এসো।
My lord, may I submit one thing, my lord? Oh, sorry, I am very sorry, my lord.
19th. On 19th. The matter will appear on 19th of June.
19th of June, my lord. Yes, I am grateful to you, lord.
My lord, next matter, item number 9. It will be obviously listed maybe on next Monday, but instead of Monday, if it be listed on Tuesday, it will be very, I will be obliged, my lord. Item number 9.
Lord, one,
obliged.
Lord, one indulgence I'm praying before. Item number 11 is the review petition, my lord. It is pending for a considerable period. Before that, if your lordship kindly fix the matter on, at least we can take the chance before the July also.
You will be pushed up the list because 9 is not going to be there next week. Let us try. Monday, try your luck on Monday. রাখুন এটা judgment মনে করতে judgment দো यहाँ
My lord, before he starts, my lord, can I submit one thing, my lord?
kindly see this 2004 volume 7 SCC paragraph 9 and 11 বার করে দাও Yes, we have just done our homework and we are, since Mr. Ghosh is not in a position to help us, we have done our homework.
No, my lord, I'm submitting, my lord. My lord, one thing, my lord.
Yes,
One thing,
please
my
see
lord.
the paragraphs that your computation of the income will not be enough to deny compassionate appointment.
My lord, I cannot go behind the scheme. Supreme Court different decision specifically stated. My scheme says what the things to be captured in the matter of computation.
Correct, correct.
Firstly, secondly, my lord, my case was single judge. You were dismissed for the reasons 2005, 3 retired. After 10 years, he cannot file the writ petition. That is the only thing. Now it is 20 years, my lord. After 20 years, he is now more than 45 years old. Now he's
বইগুলো এখানে দাও
and that judgment is, my lord, that two judgments, my lord, the Supreme Court, after 20 years, my lord, that two judgments I'm giving. Immediately after Umesh Nagpal, my lord, the Justice S.B. G.N. Rai and Justice S.B. or Justice G.N. Rai or Justice S.B. Mujumdar. They decided this thing in 96. There are recent decisions of
which is the decision which we gave it
after
to
95, after 95, my lord,
we gave you a decision of 2000 just now, Mr. Sinha. What is the decision reference? Wait,
this.
2004-7 SCC টা বার করো তো page 265. Thank you. Yes, Mr. Sinha.
I am saying, my lord, apart from penury, my lord, in this case, the honorable single judge had decided that after 10 years, this writ cannot be filed. Then, my lord, that has affirmed that decisions given by Supreme Court after immediately after Umesh Nagpal case, they specifically stated penury, immediate penury is looked into. Thereafter, the Supreme Court, Honorable Justice G.N. Rai and S.B. Mujumdar, next year, my lord, this decision was given. And then I am not going to other decisions. I am coming to the current decision of decision of Honorable Justice Dr. D.Y. Chandrachud. What he said? That two decisions I am placing, my lord. Only because of after 20 years, whether he can agitate the issue, whether he can file the writ petition after 10 years.
Yes. Show us the decision.
Second. Yes, then.
Yes, yes.
Conclusion is that immediate, the very object, last second page, very object upon compulsion of disease person who dies in harness is to relieve the unexpected immediate hardship distress caused to the family of sudden demise of the family. Since the death occurred way back in 1971, in which the year the applicant was 4 years old, it cannot be said that he is entitled to appointment after attending a majority. This is another judgment. Now here, last paragraph, in that view, it appears, then my lord, last but two. It has been last page. It has been indicated in the decisions of Women's Hon'ble, the compulsory appointment cannot be granted after a long lapse of reasonable period. And the very purpose of the compulsory appointment is an exception to the general rule of open recruitment. Is intended to meet the immediate financial problems being suffered by the members of the family of the deceased employees. In other words, of this court, the Jagadish Prasad case, it has been also indicated the very object of the compulsory appointment, disappointment, who died in harness, is to relieve immediate hardship and distress caused to the family by sudden demise and earning memory of. This is the basic value that immediate thing is to do. Now, whether after 20 years can look at now, my lord, what is the judgment given by the authored by Dr. Hon'ble Justice Dr. Chandrachud, my lord? That I am giving also. That is also reported. 2 paragraphs, my lord. This is not necessary, 2 paragraphs. Because there the Hon'ble just all issues of compulsion have been discussed. Now, my lord, will pay. This is reported in 2019, 3 SCC 653. My lord, there, page number 2, my lord. In respect of compulsion of men, or Dr. Hon'ble Justice Chandrachud has framed certain issues are framed in the High Court. That is the page 2. 9 issues are framed. 8 issues are framed. Out of which 2 issues we are concerned. Issue number 7, my lord. Page 3. Whether a person claim compulsory appointment after reasonable considerable delay. My lord, the answer is at page 29. There the delay was only 5 years. Here died 2003 and filed a petition, writ petition 2015. We are concerned with only one issue, my lord, whether a person can claim compulsory appointment after considerable delay. Issue number 7. State of Himachal Pradesh versus Sushi Kumar. Page 29, my lord. Answer is given.
29.
29.
Yes.
So far as the individual facts pertaining to the respondent are concerned, it is emerged from the record that the writ petition before the High Court was instituted on 11th May 2015. The application for compulsory appointment was submitted in May 2007. On 15 January 8, Additional Secretary had required that the amount realized by the pension be included in the income, etc. My lord, then compulsory appointment, factual aspect, my lord. Then then my lord, delay, page 30. We are not impressed with the submission that delay should be taken into account, since paragraph 8 of the scheme contemplates that a situation where all the dependent children or disabled have yet to attain the age of majority, the time limit for submission of application extended until the first of the child attain the age of 1 year. In case where each of the children is a minor, falls in a different class or category, this cannot be equated with a situation where dependent or deceased employee who was a major on the date of the death fails to submit an application within a reasonable period of time from the death of the employee. This aspect of delay has been dealt with in decisions, including.
He submitted an application. He submitted an application. It was rejected in the facts of this case. Then he went for ex gratia. Then the ex gratia was withdrawn. Then the application for compulsory appointment should revive.
Application rejected.
That's right.
He is not entitled for ex gratia.
That's right.
So wrongly filed.
Therefore, the second application was a revival of the first application.
No, first application is for compulsory appointment, and that application was rejected in 2005.
For compulsory appointment.
For compulsory appointment.
Correct.
So therefore, the ex gratia payment scheme, he is not coming.
Correct.
So therefore, he cannot file it, but he filed it. And that was
and
that was rejected 7.
True. Ex gratia scheme he filed. He could not get it.
Rejected
He
7.
could not get it, and the earlier rejection was wrong, for arguably so. Mr. Sinha, just relax and just understand. Let us try to share the point. Death happened 2003. He applied within time 2005. That was rejected. There was a scheme there. Now he changed track, whatever. He applied for ex gratia. Ex gratia, again he changed track. He met Mr. Subrata Ghosh, who advised him, why are you going for ex gratia? You want to... So he said, I'm withdrawing ex gratia. Now in this situation...
Rejected.
Rejected.
Yes.
So now the question is, now...
He's not entitled.
He's not entitled to.
Ah.
Now,
Rule
if
7.
if the earlier rejection of compassionate appointment was wrong,
Yes.
then can the court not consider it that
And
it
the
was
court-
wrong and
after
that
10
was
years,
within time?
Can he file a writ petition Rule 15?
Because ex gratia was rejected in which year?
7. Rejected 7. How long people will wait, my lord? What are the vacancies in this bank? His father enjoyed the fruits of working in public sector undertakings for a pretty long time. Now he died. Now he want to get a job. When 4,000 rupees is total father's income, after retirement his income is 4,000.
But ex gratia was rejected in which year?
Rule 7.
And he applied for the compassionate appointment for second time which year?
Second time he had not applied.
Then 2015 he came away with
He
it.
challenge, he did the petition.
In the meantime, no steps were taken.
No steps are taken. Is it a good step, sir? Yes.
Show us.
He might have representation on a side have submitted. That's all. He had not taken court. He didn't come to court.
Remember, I pointed out to your lordships earlier.
Show us.
Yes, I'm coming.
After rejection of your ex gratia till the writ petition, what are the steps taken by you? Show us.
We're at page 21. Eh, 31, sorry, 31.
No, 28.
31.
Rejected.
আসছি আমাকে বলতে দিন sorry my lord 31.
Yes.
That is from the general manager to the branch manager. That ex gratia was continuing. Then my lord,
What do you mean continued? Resubmitted.
Resubmission was directed to the branch manager.
That's right. That is not continued. Ex gratia was not continued. It was resubmitted for consideration.
No, I resubmitted earlier.
That's right.
The process was going on.
Correct.
Now, my lord, the general manager wrote to the branch manager.
Correct.
They resubmitted the original papers.
Correct.
The original papers were lying with the branch manager.
Correct.
Then, my lord, as nothing was done, then, my lord, the lawyers noticed that is page 32.
Yes.
Then, my lord, the rejection, page 34.
1 minute. What is the lawyer's notice? Show us.
Page 33, last paragraph, my lord. Last paragraph, page 33.
What happened after your first compassionate
Then-
appointment?
Then the order was passed, page 34. Immediately thereafter, writ application was moved.
1 minute. You applied for compassionate appointment. That
Yes.
was rejected.
Rejected.
What happened after the rejection? First rejection.
Then, my lord, the mother of the petitioner applied for ex gratia because at that time that scheme was there. She was a lay over.
Where is the document for that?
Yes, I'm coming. Sorry. That is at page 28. Annexure P3.
Yes.
2006.
1 minute. 28.
Yes, immediately thereafter. May 2006.
Which means On 14th May 2005, page 27,
Yes.
your prayer for compassionate appointment was rejected.
Rejected.
Then therefore, on page 28 in 2006, your mother applied for ex gratia under a scheme, which means you abandoned the prayer for compassionate appointment.
Because no, at that time there was no scheme.
Why? What was that was not the statement there. It was you were not the scheme of 2003 was there. Your penurious
No,
condition.
Came to end in 2005.
2005, August 2005, that compassionate appointment scheme was given goodbye.
But you applied in which? You applied in 2004.
2004, that was rejected
Within time.
That's right. That's right.
In 2005, exertion came.
But you could, if the rejection was wrong, you could have come then by way of a writ petition instead of claiming ex gratia.
Lay women, my lord, I cannot.
The question is, you wanted compassionate
That's
appointment. If the rejection was wrong in 2004, when the scheme was alive, you could have come to court. This is not the law.
But a woman, my lord, having no knowledge about any, even educational knowledge. It was
Oh,
not
now then you applied for ex gratia in 2006.
2006.
Then what happened after that?
Then, my lord, kindly skip over to page.
He does not apply to.
আরে ভাই আমাকে বলতে দেবেন page 30. In 2013, that was forwarded to. Then, my lord, page 31.
So what are you doing now for after so many years?
Nothing.
Waiting for compassionate appointment. Your son.
And my lord, your lordship was pleased to ask me regarding non-perilous situation.
Yes.
My lord, I am handing up two judgments. One judgment.
But there are judgment, we cannot go behind the scheme. Penury.
আসছে
Yes.
আমাকে আসতে
That is
দিন
there. Penury, what is the penury?
Paragraph,
What are the
paragraph.
things that will go?
Paragraph 13.
He had a scheme.
Paragraph 13. Exactly on the similar point. এটা দিন তো original. এটা original. Well, if the photocopy is ওটা দিয়ে দিন, original judgment is here, book is here. দিয়ে দিন।
Paragraph 13.
Paragraph 13. Where the original reference book, my lord, I have also handed up. And my lord, regarding delay, though there is no delay in my submission, my lord, another judgment of 2022.
Yes.
Regarding delay, in my submission, though there is no delay, the judgment of 2022, paragraph 9. At page 10.
So your son, who is now aged how many years?
Just.
At that time, 19 years, now 23 years more.
49.
45.
Still waiting for compassionate appointment.
Now 38 years.
Now 38 years. Now the whole point is that that part when your application for ex gratia was rejected, and then you waited for 7 years to come to court. When
No.
was it rejected?
Immediately thereafter, I moved the writ application. Not after 7 years.
He is submitting one after another application. First application rejected.
আরে আমাকে বলতে দিন না, আপনি যেমন বলছেন আমি তো বলিনি। I am just replying to my lord's questions.
Where? Where is the rejection?
Rejection is in the year 2014, page 34.
That is it.
Immediately thereafter, the writ application was moved in 2015.
Yes, that will be all. Yes, Mr. Sinha, any reply?
In reply, my lord, the rejection is that is a advocate wrote a letter after a long time. But rejection is early rejection is there, my lord. They have enclosed it. I'm coming to that, my lord. Application 5th December 2013. He filed an applications thereafter. Rejections originally in the scheme he was not there. If he is not there, then why will apply? Why will consider it? For that, can he take an advantage? It is not a rejections that he is not eligible. Scheme does not apply. So he is sending one after another applications. By that, can he extend that time limit? My first point is that, my lord, that he cannot agitate this for compulsion of permanent is the immediate penalty of the family looked into by the several judgments. One is first, my lord, West Nakbal's case is the part of my scheme. Thereafter, I placed one judgment, my lord, Justice J. N. Roy and Honorable Justice S. B. Mujumdar. That judgment I placed, my lord, they specifically stated. Then, my lord, there are several other judgments, but only I'm placing the judgment of the Supreme Court, authored by Dr. Dua issue. They are also said immediate. The one issue was framed whether person can claim compulsory appointment after considerable delay. Issue number 7. There is answer no, he cannot. He cannot. There is one part of it. The other part of it is a penalty, my lord. At the material time, he was getting 4,000 rupees at the time of violent service. Now, after death, total income comes to 4,000, about 4,000. That is why, if you could manage his family with the 4,000, then why will not manage their family after death of his father? 2 persons now, after with the 4,000. 4,000 definitely penalty. I am earning 50,000. It's still I am paying my penalty is there. Penalty is everywhere now. My lord, make questions. The 4,000 is not a penalty, and in that square meal is possible. But he was working in that situation 2003 in that situation only. By death, he can improve this situation. His family standard can be improved by his death.
And what was your financial scheme then? Just show us.
Financial scheme, what are the things that we looked into scheme basically provides? What are available? I have given the credit. What are available, my lord, that is there?
Show us.
I'm coming to the scheme, my lord.
Show us once more.
That is page, my lord, page 2003, this scheme was applicable. The financial condition of the family to be looked into under the scheme, paragraph 10, my lord, page 21.
Yes.
Page 21, paragraph 10. What are the things I am supposed to look into under the scheme? Family pension I have taken care of. Gratuity I have taken care of. Employers' contribution provident fund taken care of. Any compensation paid to the bank? No, I have not paid. If that is paid, that is taken care of. These would be an addition. So I have not taken it. This is an addition, if it was there.
Provident fund paid.
My lord,
Provident fund paid.
paid. Provident fund paid, family pension, he is getting pension. Now possibly now
Gratuity.
pension amount will be much more than that.
Gratuity paid.
Gratuity paid. Contribution to provident fund paid. যাও না মানে these are the things, if it was there, it would take consideration. So first argument, my belief argument is that delay. After 2003 diet, after 20 years, this whether it's penury or not, it should not be considered valid. Second argument is that time what penury was there considered according to the terms of the scheme by who can consider it? Only the competent authority. Because Chief General Manager is the head of the entire West Bengal circle plus Sikkim and Andaman and Nicobar Punjab. Zonal manager for recommends that matters little because he is to take care of our entire circle. In some circles, my lord, I'm not official, I cannot say that. My lord knows how the union influence is there. So that is why many times recommendation sent, but I cannot submit it in the court. But I know it, practical experience, I know it. Branch manager, what are the pressures are there? What are the pressures of zonal office is there? That is there. But I cannot submit it openly in the court. But so therefore some recommendation came, so I have to give the appointment. That's not a correct matter. It is the Chief General Manager. He is the only authority to approve the scheme and terms of the scheme. And Chief General Manager, in his wisdom, considering all other aspects, all other persons considered, he decided he was earning 44,000 rupees. Now he is earning 4,000, getting 4,000. So there is no penalty.
Ashok. Anything more?
Please note. I will.
Third parties reserved for reply.
Another document, my lord, page 59.
For delivery of what?
Page 59 of the opposition of my learned.
Demon. এটা আমার কাছে পাঠিয়ে।
Page 59 of the opposition of my learned friend.
Third, নামটা দিয়ে দেবেন। Hearing stands concluded, reserved for.
Is a circular of 2014 of the bank.
Judgment গুলো নিয়ে
2014 of the bank circular.
ওইগুলো পাঠিয়ে দেবেন।
Page 59.
Yes.
Kindly go to page 60. Page 60. Serial number 4.
At page?
Page 59 is the circular of December 27, 2014. The next page, serial number 4. 59. What the bank says? Both the modified scheme will be effective from 5/8/2014 and all cases of death, premature retirement on medical ground occurred before 5/8/2014 will be dealt with as per the respective old schemes. Sir, I have already submitted that judgment.
Very well. Reserved for judgment.
Well.
Enough. বইটা দেখে ফেলেন। Mr. Ghosh, your junior has helped us. Thank you.
No, I am sorry for giving you lots of trouble, man.
No, your junior has now been very accurate.
Because I was in fact.
We appreciate your accuracy. In the second half, you have assisted the court. Thakur.
But I'm appearing for the respondent, my lord, in this matter. Mr. Samrat Sen had extensively argued this matter, my lord. Zana, this is with regard to that, my lord, allotment of 5 kathas of land in Salt Lake, my lord. Your lordship had heard, my lord, this matter. But I'm appearing for the respondent, my lord.
We cannot.
My lord, only one thing, my lord, your lordship will kindly, my lord, I have prepared 8-page written notes, my lord. It is a very concise, very thing, my lord. If your lordship kindly permits me, I will
We
file
will not.
these, my lord.
We cannot. We cannot take this thing
My
because.
lord kindly considers, my lord, the petitioner, my lord, this been pending since.
Can help you with the notes. If you can.
My lord, I've prepared the notes, my lord. Kindly, my lord, he's 85 now, my lord. Your lordship had. Well, this has been. My lord, this is the notes, my lord. It's a very short, and I've dealt with their arguments side by side, my lord. It was on.
They are not ready with their notes.
My lord, if my lord,
We can
they
file
can-
on the
well, they
next,
can file.
by next week, we can prepare our notes. Mr. Sen had,
Very short, my lord. Very short, my lord.
No.
we are supplied with a
Sir.
copy of the arguments. And Lord friend is going to make.
Well, it's actually a
We can respond to that.
6-page note, my lord, and 7-8 pages. I've just
No.
dealt with their argument.
Ashok. Sorry.
My lord kindly considers he's 85, my lord. Now, my lord, kindly, my lord. This is a matter, my lord, which needs your lordship's mercy, my lord, because.
No, what
Well,
is
it's on very-
mercy? He is 85, I'll be 62. Everything will happen in
My lord,
life.
kindly, my
But
lord,
the
because-
question is,
My lord-
this matter was not brought to our notice earlier. Last it
My lord, it
heard on
was, my lord,
April 23.
In fact, if your lordship considers your lordship's earlier order, my lord, also in 2021 thereafter, my lord, that is why I prepared a very short note, my lord, very short note, my lord.
Wait.
Because the point involved is, my lord, very short, my lord, if your lordship kindly permits me, my lord.
He has not yet argued against your notes.
He's argued, my lord.
Yes.
They have finished the submission.
Mr. Sen had completed his submissions. He
I was
in-
supposed to give reply, my lord. It's a very short, my lord. I'll just hand over my notes, my lord. I won't take.
1 minute, you think you have
My lord,
this
my lord.
ace of
Only-
cards with
no,
you
no,
with
no,
your
my lord,
notes.
no, my lord. Only because of my client's age, my lord, because my lord, I have, my lord, lordship will kindly imagine my situation, my lord. That is the difficulty, my lord.
You are emphasizing on the word notes because of obvious reasons.
No, no, no,
Page
no.
note. It will obviously
No,
be
my lord. I understand, my
anxiety.
lord. Your lordship has taken the trouble, my lord, and I understand the paucity of
This was
time.
an assigned matter before this court.
Yes, this was.
Not an assignment.
My lord, in 2021, my lord, it was perhaps.
Yes, Mr. Shen. What is your
Lord, whichever day your lordships have time to hear it, I'm ready to assist your
question
lordships.
of another date of hearing just cannot arise? You can understand what is the.
Yes, I understand your
You are
lordship.
under pressure, Mr. Kankani is under pressure.
I'm under.
We also
lot of
I
pressure.
appreciate, Lord.
My lord, I am under. My lord, kindly, my lord. Your lordship will help.
File your notes, Mr. Sen. File your notes. This is a 94 matter. We shall deliver.
Grateful, my lord. My lord, I am filing mine now, my lord.
Party slash are represented. Full stop. Hearing stands. Parties. By when will you file your note?
Lord, I understand your lordships, Lord.
By next week?
Yes, Lord.
Next week, which date approximately?
Lord, lordship's original side day, Lord, if your lordship gives me Wednesday, the Friday, it will be very kind of your
Very
lordship,
well,
Lord.
very well, very well.
At least a week, Lord. Although, Lord, I appreciate, Lord, the time is becoming short for your lordship.
I'm grateful, my lord. I'm
Very
grateful to
short
your
for
lordship.
We were, our attention was drawn to the writ petition. It is of 94.
My lord, I'm grateful, my lord.
Leave
for
it,
the
leave
pressure.
it at that, leave a writ petition of 94, whatever the pressures, that is what struck us. So old writ petition of 94, whichever way it goes.
My lord.
Paper book ache to. Party this slash are represented, full stop para. Hearing stands concluded, full stop para. Notes of arguments are filed on behalf of the
Writ petitioner respondent.
respondent in the writ petitioner slash the respondent in the appeal. Also, the appellants, the state of West Bengal, are permitted to file their notes of argument are permitted to file, as prayed for, their notes of argument positively by the 16th of January 2023.
My lord. June.
16th of June 2023.
My lord, will it be your lordship's pleasure, my lord? The judgments, my lord, there are 4 judgments. May I just mark, my lord, the paragraph for your lordship's convenience?
Hand
my lord?
over the compile.
My lord, may I hand over, my lord?
Yes.
May I, to save a lordship's
Mark the
time, my lord?
paragraph.
May I just?
Yes.
My
You
lord,
share the judgment.
I will, my lord.
You have to.
No,
You
that I will
mention
do.
that in your note, these judgments.
Yes, I have referred to these judgments only to save a lordship's time. May I mark it, my lord?
Correct, mark the paragraphs. Indicate the paragraphs
That
on
is
the
what-
index.
Grateful,
That is
I'll do that and I'll find.
Yes, that is what is required. And that is paginated.
Yes, everything, my lord.
And please
My lord,
show it to Mr.
To
Sheikh.
give as much less trouble, my lord, to your
That is
lordship, my
right.
lord, I will try and do it, my lord. I will hand over a copy.
Reserved for judgment.
A copy দিয়ে দাও, judgment এর কাছে একটা।
আমার কাছে পাঠিয়ে।
এটা extra।
Yes.
এটা আপনাকে আগে যেটা দিয়েছিল ওই নোটটা, ওই নোটটা দাও বুঝবো। Grateful.
Yes. Next matter.
My lord, I beg to appear on behalf of the petitioner. But this matter pertains to, if my lord may kindly recalls, I may put it in a very short, my lord. It was previously it appeared before your lordship on 15th of March, whereupon your lordship was pleased to direct me to serve the copy of the contempt application upon the alleged contender. My lord, I have served, my lord. And the matter pertains to, my lord, grant of the career advancement scheme in West Bengal Transport Corporation. My lord, we sitting with Justice Mukherjee was pleased to pass an order, my lord, the career advancement scheme which is applicable to the state government employees, whether applicable to the West Bengal Transport employees undertakings of the West Bengal Transport Corporation. To that extent, my lord was pleased to, if my lord may kindly comes to page 54.
Order passed by?
My lord, passed by your lordship sitting with the Honorable Justice Ananda Kumar Mukherjee as his lordship then was. And the ultimate paragraph, it has page 20. My lord has hold.
The service upon we directed service.
Yes, I have served.
On?
Upon the alleged contender. Alleged contender is, my lord, one Manoj Kumar Pant, additional chief secretary. But the primary violation is that, my lord, if my lord may kindly turns to page 55 once.
Where is the proof of service? Mr.
My lord, I have given, my lord. They have overreached the court. I will show to your lordship how they have overreached the court. It is a no appeal has been preferred to the Honorable Apex Court assailing this order.
Has it been delivered?
Yes, my lord. The track report says so. The first violation I'll show to your lordship.
1 minute. You'll show the violation
But yes.
after he answers the rule.
Yes.
Arising out of the judgment and order dated 22nd July 2022. Passed by a concurrent honorable division bench. Of which one of us, within bracket Aman Namta, was a part. Judgment order 22nd July 2022 in the appeal being APO 139 of 2021, in which one of us, Aman Namta, was a part. The contempt application, Paradev, has therefore appeared before this bench upon the retirement of the second honorable judge, comprising the bench, which passed the judgment and order dated 22nd July 2022 in APO 2022 in APO 139 of 2021 within brackets Supra. So, para Mr. Basu, former learned counsel appearing for the petitioner in the contempt application, draws the attention of this court to its previous order dated 15th March 2023. Full stop. It is submitted that by the said previous order, a notice of the contempt application was directed to be served upon the alleged sole contender, who was also represented on the said date by his learned lawyers. Full stop. Upon such service, an affidavit was directed to be filed. Affidavit of service was directed to be filed on the next date. Full stop. When the matter has appeared today, Mr. Basu produces an affidavit of service which discloses service of notice upon the alleged sole contender as directed by the order dated 15th March 2023 within brackets Supra. Full stop. The service is shown to be complete. Full stop. Let an affidavit of service, let the said affidavit of service be retained with the record. Full stop. Today, none represents the alleged sole contender. Full stop. No accommodation is sought either. Full stop. Accordingly, let a rule be issued against the alleged sole contender, returnable on 16th.
Yes.
16th Desh. Returnable on the alleged sole contender. Returnable on the alleged sole contender. Returnable on the 23rd of June 2020 at 2 p.m. Registry to take steps.
Much obliged.
May it please, my lord, I appear for the appellants. Mr. Dhruvo Ghosh is leading me in the matter, my lord. He is not available today, my lord. I'll be requesting for the matter to be adjourned for the day.
Let this Ashok.
My lord, my instructions are that it has been fixed on next Wednesday, my lord. Let the matter appear on the next Wednesday.
Orders?
Next Wednesday.
Ashok. And the matter is called, Mr. Your good name?
My name is Altamash Alim.
Please write it down and.
Yes, my lord.
Mr. Advocate, Commandant and Advocate, appearing for the appellant.
Yes, my lord. Appellant.
Praise for an accommodation. The respondent is represented by Mrs. Please write your name and talk to each other later.
Yes.
Finish up the business of the court and talk to each other afterwards. Please write your name and hand over the. Because free, then please discuss among yourselves. We'll let the matter appear next under the same heading for hearing in the monthly combined list of July 20.
Grateful, my lord.
Let the matter stand adjourned. কোনো পার্টনার নেই তো
Yes, my lord. I have given the name. Yes, my lord. I have given the name. Respondent, appellant. Grateful. Yes, my lord.
Whatever lordship deems fit and proper, my lord. If my lords want to hear it, my lord, I am ready. And if my lord, I understand this matter has been specially assigned to your lordship. No, so no, but still July to automatic. The lordship will can. Specially assigned. So, my lord, if lordship, my lord, can otherwise release it also if lordship so desires.
A part heard and a specially assigned. A part heard can be released. A specially assigned, the bonus.
It has to be till lordship is.
Till his lordship, the first bench decides what to do with the assignment. It's not on our will.
I see.
There's a
I understand.
technical understanding.
I understand.
An assignment is an assignment. You cannot free yourself of the assignment till other factors happen. Anyway, not this week.
Very well.
Monthly list of July. Order pass করতে হবে না আমি দিয়ে দিতে পারি monthly list of July.
Lordship.
My lord, may I be permitted to mention one matter, my lord? I don't want to trouble your lordships, but the hearing has been completed in this appeal. This appeal pertains to the fixation of dock pilots. My lord has been pleased to reserve the judgment.